rest.
Well, thank you, Mr. Speaker. And like so many of my colleagues, I'm happy to be able to speak today with respect to my colleagues' private members' bill, Bill C-489, an act to amend the Criminal Code and the Corrections and Conditional Release Act. So I'll say that I'm proud to support this bill. It's another great piece of legislation that's been brought forward either by our government or members of our government that bring forward what I like to describe as, in many cases, common sense and practical solutions to some of the issues that are faced in our criminal justice system today. It reminds me of a couple of other pieces of legislation that we've brought forward. For example, when we brought forward the issue with victim surcharge, well, part of the problem in that case was that judges were not imposing the surcharge. And when they didn't, they were supposed to give written reasons. And we found out that in 90% of the time when they weren't imposed, they didn't actually give written reasons. So we made it mandatory that those victim surcharges would be put in place. This bill continues to support our agenda to make sure that our streets and communities are safe for all Canadians. And Mr. Speaker, it does it in a couple of meaningful ways, and I'll go into that as I speak about it. But in a quick summary, it will ensure that sentencing courts and parole boards more regularly impose conditions, when appropriate, to prohibit specific types of contact between offenders and their victims. It proposes that such conditions be imposed to protect witnesses and other individuals that need similar protection. Again, I say these kinds of things that are being brought forward just make sense. If you ask the average person, should there be conditions to prohibit types of conduct between offenders and victims, people would say, yes, that makes sense, Mr. Speaker. Mr. Speaker, I'm not surprised that in many instances the opposition and opposition members would suggest this bill is not necessary because the current law already provides that this could take place. But that's part of the problem because these conditions aren't being put in place in many circumstances. The court, and as I say, that's the same issue as we go back to talk about the victim surcharge. For example, in this case, prohibition orders always include 3 mandatory conditions. These conditions are to keep the peace and be of good behavior, of course, the promise to appear when required, and to notify the court or the probation officer in advance of any change of name or address, or any change of employment or occupation. Mr. Speaker, a sentencing court may also impose any of the optional conditions that are set out in subsection 732.1 sub 3 of the Criminal Code, which include drug and alcohol prohibitions, restrictions against travel, weapon prohibitions, requirements to support dependents, and community service conditions. Mr. Speaker, the list of mandatory and optional conditions do not include conditions that restrict contact between offenders and victims. And this is what I go back to when I say these reforms are such common sense things. You would seem to think that that would be something that's sort of at the top of the agenda, restricting contact between the perpetrator of a crime and the victim of a crime. Sentencing courts are also not required to provide reasons when they don't choose to do that. And I would submit again, that makes absolutely no sense when you take a moment to think about it. Lastly, subsection 732.1 sub G1.1 provides that a residual condition under which a court may impose reasonable conditions that are desirable for protecting society and for facilitating the offender's successful reintegration into the community. It is only pursuant to this residual provision that a sentencing court has the authority to impose a condition that would limit contact between the victim and the offender, or prevent the offender from moving across the street from the victim. It's a residual provision. This is why a reform like this is so absolutely necessary. Mr. Speaker, there's some examples in the case law where sentencing courts have imposed conditions restricting contact between offenders and their victims. For instance, in the case of R versus Horton, the offender, a G20 demonstrator, was made subject to a condition of non-contact with a named police officer who was a victim of the offender's actions. This said, the appellate decision on the use of this provision underlined the problems with respect to its use, in limiting contact between offenders and their victims. Specifically, the courts may refuse such conditions if by their nature they impact against the successful reintegration of the offender. This is upside down. This is topsy-turvy. This is what we're talking about. You're putting the rights of the person that perpetrated a crime ahead of the rights of a victim. These are exactly the kinds of things, these imbalances, that need to be addressed in our justice system. Mr. Speaker, the Supreme Court of Canada stressed that in order for probation order conditions to be lawful, they must not offend the objectives of protecting society or the successful reintegration of the offender. So they're saying both are important and have to be given due consideration. In two Supreme Court of Canada cases, R versus Proulx and R versus Shocker, we're very clear about this principle. There must be a nexus between the condition imposed, the offender's behavior, the protection of society, and the successful reintegration of the offender. We're trying to reinstitute that balance, Mr. Speaker, to make sure that the victim and protection of society is going to be back in that equation. However, Mr. Speaker, as I say, the offender's interest supersedes the rights of the victim and the protection of society, and that is exactly what we're going to address with this legislation. A good example of this can be found in the decision of R versus Roe, where the Ontario Court of Appeal found that a condition of directing a repeat domestic offender, violent offender, stay out of the province of Ontario for the duration of the probation order would be an obstacle to the successful reintegration of the offender. A repeat domestic violence offender, that kind of an order is an obstacle to their reintegration. Well, what about the obstacle to the victim, Mr. Speaker? That's what we're trying to put back in focus. And this is a problem which makes relying on the existing provision difficult, and why we need this reform. And as I stated before, Mr. Speaker, furthermore, the courts are not required to provide reasons for not imposing such conditions. So we don't even know if that condition was considered by the judge, or why the judge considered it and didn't impose it. These are the kinds of problems that we have with the existing legislation. So as a result of this, non-contact conditions simply fall through the cracks. And victims are saying, well, why didn't somebody think about me? Why am I falling through the cracks? These are important reforms. So, Mr. Speaker, when you look at these considerations, I think Bill C-489 proposes a really real sound solution to the problem that we're talking about. And I go back to this again. What I say oftentimes is, it's common sense. It's the kind of thing when you explain to the average person on the street that we're making this kind of a change, they say, really? The law before that didn't provide for this? They can't believe it. It's like right now the Justice Committee is studying some of the changes to not criminally responsible. And we let them know what some of the changes are. They can't believe that these changes that we're proposing aren't how it exists now. So Bill 489 proposes to amend it. It proposed to amend the probation provision to make it mandatory for the courts to impose non-contact conditions unless there are exceptional circumstances not to do so, or unless the victim or other individuals mentioned in the order consents. This is going to give more protection, more mental protection as well, to victims. You can imagine the circumstance where you're a victim of a domestic violence case and the perpetrator continues to be in contact with you, and you're saying, why wasn't some kind of prohibition order put in place? Mr. Speaker, many of the same concerns I've identified are applicable to other orders, and this is why Bill C-489 proposes that the same type of conditions be mandatory for conditional sentence orders imposed by sentencing courts and for all conditional releases imposed by the Parole Board of Canada. This bill will also require courts to consider imposing such conditions in all child sex offender peace bonds. Mr. Speaker, again, this just makes sense. It's a reform that we absolutely need to move forward with. Mr. Speaker, victims and their families and witnesses need the protection of the courts and parole authorities when an offender is released into the community. This is the kind of stuff that we have to get done. It's going to provide more safety and ensure that witnesses and victims are protected. Mr. Speaker, this bill is consistent with our government's commitment to putting victims' rights back on the agenda, and that's why I'm proud to support this bill. Thank you, Mr. Speaker.